Hey guys, Courtney Clenney has big problems sitting in jail awaiting trial for murder. Now she's got another problem. The estate of the victim and ex-boyfriend Christian Obumseli is suing her. We've talked about in the Brooks case about how it can be a good idea to get a money judgment in civil court because the criminal restitution system has a lot of limits and it's not designed to have the same scope of recovery or collection methods that a civil judgment can provide. Now, her name is at the bottom of a list of entities being sued for this. How can someone else be responsible for her act behind closed doors during a domestic violence incident? Good question, astute viewer. Are these other companies really bad actors who are responsible or just potential sources of money? So in addition to Clenney, One Paricio Condominium, Aleros Real Estate, First Service Residential, and Universal Protection Service are all being sued. The original suit for everyone, including Clenney, is based on negligent security. It's been amended, and we'll talk about that. Okay, well, since Christian was killed in the incident, obviously he can't sue, but his estate can and survivors. His estate acting under the direction of its personal representative. Oh, wait, the suit says soon to be appointed personal representative. Can you act as the personal representative when you haven't been appointed, which is what soon to be appointed means? What's happening here in Florida? If I go to a concert and want to get in and get up to the turnstile and go in, and the security guard says, wait a minute, I need to see your ticket. And I say, wait, I'm a soon-to-be ticket holder. He's going to say, well, then come right in and go straight to the front. Now, I think you have to have the ticket first, and I'm kind of surprised that you don't become the personal representative before filing the suit. But whatever. I'm sure if that's an issue, the defense will raise it. Now, why not hold off on the suit until you do get appointed? This was filed just less than a year after the incident, so maybe there's a claim with a 1-year statute of limitations. I didn't see that in the suit, though, and there aren't that many claims that have such a short statute of limitations, and it just didn't find it. Maybe something's going on with one or more of the parties that's causing them to get this show on the stage ASAP. Maybe also there's a case that says, hey, personal representatives can be people who are pretty sure they'll later be personal representatives, so go ahead and sue. Whatever. Let's keep going now that we've discussed the oddities of the plaintiff's side. The suit says it's for damages in excess of $50,000. This is normal jurisdiction-type pleading. They could be, and likely are, asking for millions of dollars, but they're just pleading what looks like a jurisdictional minimum. That's typical and sometimes required. As I've said before, there are often procedure rules that keep parties from pleading specific high levels of damages that grab headlines like $50 million for hot coffee and stuff like that. So they'll just say, plead the jurisdictional minimum and in excess of that, and the exact amount will come later. Now, I mentioned this suit was based on negligent security. This concept gets heavily involved with our old friend proximate cause. But just to give a high-level concept of it, the idea is that if you, say, run a business, not necessarily business, but we'll pick a business, and entice the public to come to it. You're running sales and ads and things, and you have a reason to foresee, because remember, reasonable foreseeability ties into proximate cause, crime occurring at your business or on your premises, then you have a duty to take steps to mitigate the danger. You could warn people, you could light up the parking lot, hire security guards or whatever. You're not an insurer. You're not automatically liable. You have to have this foreseeability, and then you have to fail to take reasonable steps. So you just have to take steps to protect reasonably from the foreseeable type of crimes on your premises. And maybe you know about prior burglaries or assaults or whatever. It's kind of like if you know that you have a wet floor that you just mopped, people have fallen on wet floors in the past, it's reasonably foreseeable that could happen again. You put a sign up next to it. If you don't and somebody slips, it's the old slip and fall case. So if you have criminals lurking around, like I said, maybe light up the parking lot, security patrol or whatever, it just depends on the circumstances. But the idea is if there's a reasonably foreseeable danger on your premises and you're inviting people to come to it, then you've got a duty to mitigate. So we'll keep Clenney a second because she actually did the stabbings or throwing or whatever. And we'll look at these companies collectively because the allegations are kind of similar on them. And the notion is that these companies failed to take reasonable steps to address potential crime. The alleged acts of negligence are set forth in 2 buckets. And bucket 1 says, hey, they didn't provide adequate security for the premises residents, the invitees, people who were, kind of asked to come there, and the public in general. They didn't warn, protect, guard, or secure the safety of the premises. They didn't police, patrol, guard, deter, and otherwise provide adequate protection. They didn't hire or retain adequate security personnel. They didn't have enough guards in a visible area. They didn't have enough security guards to protect the subject premises. They failed to hire and retain competent security guards. They failed to properly train them. And they didn't have adequate security policies or security measures, even though they should have known that. And that was a violation of what, normal caring businesses would do in that area, plus additional acts of negligence not discovered. So the second bucket is there's inadequate or non-existent visible deterrence to prevent criminal assault. Second part of the second bucket is inadequate or non-existent physical deterrence. And criminals could carry out physical assaults within the subject premises without fear of being caught, discovered, or prosecuted. The atmosphere was created at the premises that facilitated the commission of crimes against persons. So that does all sound pretty terrible, right? So those are reasonable things to allege. You set up a business, you have people come there, there's crime all over the place, you don't do anything about it, is kind of what they're saying. Except maybe the part where they said acts of negligence they haven't discovered yet. Undiscovered negligence isn't really the basis of a lawsuit because you're supposed to show the negligent act. But it is totally okay to make negligence that you discovered during the lawsuit part of your claim. So that's just neutral in my book. They do have all these other things they cite as negligence. It's not all stuff they don't know yet. But even if all these things are true, do they apply here? This is the causation, factual causation and proximate causation. You have an injury and you have somebody who was negligent. How do they connect? Because as I understand it, Courtney and Christian were behind closed doors in the condo in their residence when this happened. How does the number of security guards milling around the lobby affect that? Or how many security guards are present in a visible area? Or failing to warn residents about potential crime having anything to do with what happened here? Should they have sent a flyer to every resident saying, please don't stab people you live with, and please watch out about getting stabbed by people you do live with? And if they hadn't sent a flyer out like that, would it have mattered? And do they have a duty to do that? So for me, of course, it's possible they have a narrative that would make sense to me. Not that they have to convince me, but I don't see it. If Christian had been attacked and killed in the parking garage or the lobby or on the common grounds, yeah, I get it. Possible liability. If he'd been attacked by someone who snuck in the building and hid in the condo and waited, yeah, I would get that too. Possible liability. But he was stabbed by the woman he was living with. They both had permission to go into the building and get behind closed doors in the condo. How's that a security issue? To me, the alleged breaches of security are not the factual approximate cause of Christian's death or any significant factor. Do you see that differently? Now, granted, if there's some other narrative that they knew this assault was going on, they didn't timely provide aid or something like that, yeah, okay. I mean, there could be things. I just don't see them alleged, and I don't feel that the ordinary acts of security, like putting signs up warning about crime and lighting a parking lot and having a security guard roaming around, really have anything to do with two people getting into a fight between themselves where they live with the door closed. They're not going to have a security guard inside the condo with you. Well, I'll take that back as we proceed through this lawsuit. So how about the suit against Clenney? You think that'd be, hey, she had the knife and she used it either intentionally, recklessly, negligently, whatever, but she had the knife and she used it in a way that caused Christian to be stabbed and die. That's pretty simple, right? But that's not the claim in the original suit. The claim was literally the same as everyone else, negligent security. Courtney didn't hire enough guards or warn the public or have guards in visible places or have adequate security policies. And yet she's the one who was doing the stabbing, right? It's literally cut and paste the same allegations as the companies. Now, I'm an unfrozen cave, simple country lawyer, but that's strange to me. She and the dude live there. She kills him. And she sued for not warning the public that there might be crime and for not hiring security guards who wouldn't be in the condo anyway. I don't get this one. In my world, I would have sued for, and stay with me on this, her killing him for being the person who actually did the negligent or intentional thing. Like if you ran me over, I'd sue you for that and not for not giving me a brochure about how dangerous roadways can be. The original suit never even said she stabbed him. It said he was fatally stabbed. It doesn't say by who. What? For whatever reason there was that was the original claim, and for an anticipatory dunk by me on disputers who are about to explain to me how that makes sense, this has been fixed. On April 14th, the plaintiff filed an amended complaint that deleted this negligent security claim by Courtney and substituted a good old-fashioned battery claim. In this, they say she intentionally touched, struck, or made contact with and or stabbed Christian against his will, and he died as a result. As a direct and proximate cause, she is liable. That sounds straightforward and makes perfect sense even to me. Now I recognize that Florida is going to Florida, but because of how strange this suit started out, I will unfortunately be interested in how the defense answers this. They're still all waiting, getting extensions of time, being served with the summons and stuff. And of course, now they have this amended complaint. So we'll see how it goes. They're trying to get some money, a civil judgment against Courtney, and they also want a civil judgment against all these other companies that surrounded the situation. I'd have to hear more from them before I'd buy into any of that. I just don't see security around the building and in the lobby common areas as having anything to do with two people getting into a fight in their condo and one of them killing the other. We'll just have to see. Well, that's it. Thanks. Bye.